directed the court by an order dated 5th December 2014 to submit an application afresh from any of the sons and other specified relatives and disease licensee. After that, two legal heirs, namely Rabindranath Mukherjee, first son, and Sri Subhas Mukherjee, second son, submitted applications for obtaining MR license on compassionate ground. It is further stated that both the applications were rejected by memo number such and such dated 1st April 2015 due to the contravention of para 26 the West Bengal Public Distribution System Maintenance and Control Order 2013, which states that it is mandatory to submit NOC from all legal heirs to the deceased of the MR dealers. The copy of the said order dated rejection orders is annexed herewith. It is stated that the challenge of the said rejection orders, another writ petition was filed before the Honorable Court, and again on the court was directed to submit application afresh from any of the sons of other specified relatives of the deceased MR dealers late Gauri Rani Mukherjee on compassionate ground under provisions of the Control Order 2003. Then one legal heirs in Subhas Mukherjee, Rabindranath Mukherjee first son, did not give NOC in his favor of the applications on Subhas Mukherjee second son, but provision laid down in 19 to GO of 7044 FS dated 18 November 2004 under PDS Control Order 2003 postulates that if out of the several legal heirs, only one legal heir is the claimant, he is required to submit NOCs and other legal heirs along with the prayers. Since Subhas Mukherjee did not submit the same, in application was rejected by memo number such and such dated 18th August 2015. A copy of the said order dated 24th April 2015 and said circular dated 11 November 2004 and rejection order dated 28th 8 of 2015 as annexed herewith and collectively. It is further stated that Mr. Subhas Mukherjee died on 27th September 2015, and after the death of Sri Vasudev Mukherjee's grandsons of the deceased MR dealers as Gauri Rani Mukherjee applied for the compassionate appointment, which was rejected by memo number such and such dated 21st August 2018 on the ground that the grandsons cannot be family members of the deceased APS dealers. As per the clause 20. If my lord lordship kindly clause to name of the family definitions of the family, my lord, in 2013 control orders. পরে দেখো আগে দেখো তখন তো অ্যামেন্ডমেন্ট হয়নি। এটা আমি বই থেকে দেখো 2A, my lord, the family members means spouse, parents and sons in.
Yes.
That was annexed also, my lord. 19, my lord.
Yes.
Clause 2 of the said control orders, subclause M following the spouse, parents
Definition
and
of family member.
family member. But the applicant is come under the zone of the family members. So that the rejection was given on the grounds that he is not come under the family members.
No, it is a submission that after that one amendment is there, wherein the
But when the amendment was made, application was made prior to this amendment. But the amendment is not come into effect and rescue the petition as well. Because the application was made after amendment, prior amendment. Before amendment. That is not the clarificatory, my lord, is the prospective effect one, not retrospective one.
It is their submission that it is retrospective.
Retrospective effect.
It is their submission that the amendment have a retrospective effect. What is your submission?
That is not retrospective because at the time of applications, that amendment was not made. Amendment is after the application was made, then amendment was made.
So when the order was passed, there was no amendment.
No amendment is there. He is not get the benefit of the amendment. And for this reason, my lord, behind this, that is elaborately given reason, the orders is theirs, my lord, rejection orders is theirs, and my lord, for this grounds, his application was turned down, my lord. That is, my lord, page 16 of
So
this.
what about the Control Order 2003 regarding the definition of family members?
At the point of time, my lord, he is not come under zone of consideration of the family member. 2003 also.
2003 also, the grandson cannot
Cancel
come.
cannot come.
Now,
My
what
lord
is the
was well
provision
aware
for
that because
2003?
one matter was moved justice seniors court, and that was amendment was common effect of this, right? After that, my lord, the pursuant to the lordship direction that was considered by the department, and the amendment was made, and that was included on the family definition of the family. And my lord, the rejection was space 16, my lord. 16 of the opposition. The matter is being taken up consideration on in compliance of the order of Honorable High Court, Calcutta, passed in 24th August 2015 in connection with WP number Subhas Mukherjee versus Petitioner State of West Bengal, having regard to the orders dated 5th December 2004, when it is directed to submit the application afresh from any of the sons on other specified relatives in disease of the MR dealers. And there's a specification is there the relatives, my lord. Let Gauri Rani Mukherjee, and decisions must be taken under Control Order 2003. It is also directed that the applications will have to file the applications with consent of the other legal heirs, and others thereafter the opportunity of the hearing shall be given prior to take up the final decision. The applications in Form C and A along with others related papers on obtaining MR dealership license on the compassionate ground has been submitted by you on 15th August 2015 after thorough scrutiny. It is found that NOCs of the one legal heirs, namely Robindranath Mukherjee, eldest sons of the deceased MR dealers, late Gauri Rani Mukherjee, is not submitted in favor of the applicant. But provisions laid down in clause 19.2 GO 7044 of FS dated 18th November 2004 under the PDS Control Order 2003 that if out of the several legal years only one legal years is claimant, he submit no objections other legal years along with his prayers. Hence, the undersigned has to come to the conclusions that your applicant are obtaining MR license of a
That is
deceased
the rejection of Subhas's application.
applications. And my lord, next in the Buddhadev Mukherjee's prayers, in respect of the prayers in license of compensate ground, page 17, my lord. In response of the prayer of license of compensate ground stated that as plus clause 2 of subclause M, PDS Maintenance and Control Order 2013 read with order GSR 630E dated 13th August 2001. A grandson cannot be family members of the deceased FPS dealers. Amendment copy enclosed herewith. Besides, no department notifications granting FPS license is published and news of paper publication cannot be entertained. And that was rejected on the Buddhadev Mukherjee matter. That's the ground because they will not come under zone of consideration 2M subclause M of the PTS Control Order 2013 and they are not the family members.
That is in respect of present petition.
Petitioners is concerned and rightly rejected the application one.
Okay. That's all.
That's all.
Okay, just submission.
Yes, sir. Only submission. Order was
21st of August. Before your cancellation? No,
after that.
after cancellation.
When I have challenged of my challenge, amendment has been took place. I have given judgment of the court where intended when it was obligatory, it should be given retrospective. Amendment is a clarification that incorporated certain parts.
clarified the position. All of the PVC son is entered in kind with the rest of them. During the need, the Government of West Bengal Finance Department clarified this. And coming with product replacement of family member and entitled to get the loan.
What is the amended? Okay, we just given.
7 is amended. I have amended.
Okay. Hard. Yes. The next matter.
Next matter I will address to Lordship on the next day.
Why not today?
Let me comprehend the submissions of my learned brothers.
They have submitted.
What I say, let me comprehend with the submissions that
Only allegation against you. You are the.
understand. At the same time, I have to also counter the submissions of my learned brother appearing for the petitioner. But as of today, since it's a Lordship desire, may I just begin my submissions?
You are a retired person. Whether you can entitled to get a license.
Yes, the license, so far the condition doesn't say anything that whether an unemployed or a retired person,
Yes, there are provisions.
I will,
There are provisions in compassionate appointment.
I will,
Whether you have sufficient means.
yes,
That is the only.
yes, the question is a
criteria.
sufficient means. It doesn't say whether I am a retired or I am an unemployed. It says a sufficient whether I have a sufficient means.
Sufficient means of
Now,
income.
before that, before addressing to my petition, may I just say something on their petition? Now, your Lordship has seen, my lord, that ground of rejection is this in the other petition, because at the same time, well, I would be pursuing my petition. I have to oppose, my lord, their petition also.
Very well.
So let me first address to some extent, my lord, thereafter I will continue on the next date. Now, what I understand, my lord, my learned friend, my lord, selling at the same time on 2 boats. My lord, his principal contention before this honorable court, my lord, in the other coordinate benches, that in his case, 2003 control order will apply and 2013 will not apply. And that was a consistent view of this honorable court also. Your Lordship has also found that while, my lord, the honorable...
The issue is totally separate. When Subhas filed the application for the death of his mother,
Yes.
not Subhas, earlier granddaughters has filed the application, or dispose of the application with direction or giving liberty to the applicable persons to apply.
Yes, that was the first direction. Subsequent direction was that
direction in pursuance to the direction Subhas applied.
they had applied. Yes,
Subhas
absolutely. But I am not disputing those facts.
Subhas application was turned down in terms of provision control order 2013. This court says
exactly.
the direction is in respect of 2003
The
control
order. So you have to also
Subhas application has to be disposed of under the control order 2003, not 2013.
30.
That is the till direction.
Exactly.
When
That is,
Subhas expired,
Yeah.
all cause of action goes. Now the present petitioner comes. He applied for license. Now
he applied for license.
he applied for license.
Now, my lord, while this death had occurred at that point of time, 2003 control order was prevailing. So, my lord, if any compassionate appointment is to be given, it has to be in accordance with 2003. Here, my lord, the case of Buddhadev, the grandson also was on that aspect. Even, my lord, his father also was saying that. Now, here,
in the
my
year
learned friend say,
2003,
Yes.
the year 2003, the petitioner, that is the Buddhadev, is not the son of a predeceased son.
No, the Buddhadev was so far as Subhash was
alive there.
Subhash was alive. I am not disputing. I say that it is the consistent stand, and even if it's not the consistent stand, law is very clear that while the vacancy arise on a particular date and time, at that time point of time, whatever the law is, my lord, that has to be followed. So my learned friend shows, my lord, a subsequent amendment of 2013. My first point is this.
Submission is the petitioner is roaming in between the.
I'm not even saying that. I say whatever the amendment carries in 2013, that will not apply to his case. He has to show, because 2013 control order will not apply over here. The amendment, whatever carries out, it is in 2013. So before, my lord, he enters in the room, he has to first show that he is entitled to enter into the room. I say he is not even entitled to enter into the room. He has to show there has been an amendment to the 2003 by which he could come within the definition of family.
Very good. Next.
If that he cannot show, then, my lord, so far as other aspects are concerned, my lord, those are, my lord, only, my lord, for the purpose of academic concern. Well, I will, my lord, continue my summation on the next.
Tomorrow?
Kindly do not permit me next week.
Today is supposed to dispose.
No, my lord, I have not. I'm not. Kindly,
so I fix the
my
matter.
lord, kindly appreciate, my lord, my incapabilities, my lord. My lord, I have to study, my lord. I have not studied, my lord, not feeling. Whatever I have heard now, and just to apply, my lord, so far as to, my lord, say something against his case, my lord, this is the first point that I have placed. Because so far as grandson is concerned, my lord, 2013.
Today you are not ready. So when can you be ready? Day after tomorrow or tomorrow?
My lord, then the next week.
Next
kindly
week again.
Kindly, my lord, your lordship has been always kind enough, my lord. My lord, I am not, my lord, that much of capable, my lord. Kindly give me some time, my lord, to come ready.
এটা দিয়ে দিন 29th
29th.
please take down in item number item number 1 লিখবেন learned counsel appearing on behalf of the petitioner seeks accommodation না 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 ওখানে লিখুন the argument on behalf of the learned petitioner continues. Let the matter appear in the list on 29th of April at 2 p.m.
Well, the interim order is a continuing interim order. Kindly see the order dated 17th April 2023.
In which matter?
In my matter.
Item number 1.
Item number 1. That is the case of Vishwanath. 17th April 2023. Kindly see the order first, my lord. That was the order that when the interim order was passed. 17th April 2023 by Justice Sengupta. And this is applicable basically, my lord, for both the petitions. Both are beneficiaries to this order. 17th April. My lord, I have this order.
17th April.
Yes. Well, kindly see the first order. Kindly see, my lord. I believe my copy and your lordship's copy would be given same.
আগের দিনে extension ছিল
This page and the next page, my lord. Has your lordship got, my lord?
Do not make any appointment.
Yes. This has been continuing, my lord.
This is continuing.
Yes.
Interim order is there.
Your lordship has
That's
also
the disposal of the interim matter.
Exactly.
I have taken up the
state of disposal while keep it on last
several times.
disposal is there. Next week I will dispose of the
Lots,
matter.
yes,
Today I
lots.
suppose to dispose of
Yes.
the
Yes.
matter. continues. Let the matter appear in the list on 29th of April 2025 at 2 p.m. Interim order passed by this court be extended till the disposal of this matter.
Instead of
Madam.
disposal, kindly keep
I remember next week.
I will dispose of this matter next week, Mr. Chatterjee. Otherwise, you mention this matter.
The interim order was passed because of the state. Your lordship has seen this order.
Okay,
I'm
next
not
item.
Only ground, my lord.
Item number 2.
at the point of time.
No,
I
item
am
number
not.
one and two has-
Item number 2, you are whether you are there. Item number 2, no.
I have heard the petitioner.
Now, whether you are there,
He is not.
he is not there. Argument on behalf of the parties continues. Let the matter appear in the list on 29th of April 2025
Grateful, ma'am.
at 2 p.m. এবার লিখুন, ওইটাতে লিখুন। Affidavit in opposition reaffirmed by the state respondent be taken on record.
I'm grateful. কতক্ষণ চালাবো?
এগুলো না। Next. No, I do not know.
May I please your lordship? Your lordship heard the matter.
Yes, I have heard the matter.
Mr. Some facts
The matter?
have been placed by Mr. Chakraborty, Raghunath Chakraborty,
Yes.
appearing for OHAP. Your lordship can remember two names.
You lordship release the other matter.
Why? Entire day is there.
Internal. We have already.
And
passed
your
up.
matter,
The next one.
Release Corona.
this matter, I have parted 2 days. This matter.
So
These
it-
3 matters I have parted 2 days. So it will not take more than 1 hour, I think.
1 hour takes us your lordship 4 o'clock.
Thereafter, I will take up your matter. No? You just take rest. No, item number 6. Item number 7. Okay. Let me start this. Your client is Abdul Wahab. No, Abdul Rauf.
I am Abdul Rauf.
Abdul Rauf. And submission made by Abdul Wahab.
Raghunath Chakraborty, Abdul Wahab,
Wow.
and other three learners for the state.
For the sisters are there, they have also appeared.
Now,
So the issue,
they are
so far as are good, so far as I can remember, this is the compassionate appointment. Compassionate appointment was by the prayer was by the wife and Abdul Rauf. Initially, the government has taken a stance that if not the wife, then Abdul Rauf as a second candidate. Now, after all long, when the wife of the licensee expired, the Abdul Wahab come and he filed the application. These are the writ petitions. 3 writ petitions are there. Yes.
but I am stating the facts. There are some difficulties in the matter.
Yes.
And now, my lord, I will take up first matters. I want to complete the first matter first.
First matter means
First matter,
item number 3,
three,
WPA 4740.
yes.
Your matter is third, item number 5.
Already in matter number first, I am also respondent.
Yes.
Matter number second, I am also respondent.
And matter number 3,
third, I am
you are the petitioner.
petitioner. I formulate the point touching my case also, so that I should not waste your lordship time. Now the first matter, Abdul Wahab made a prayer এটা তো না, লিফটে কোথায়? না, লিফটে। ফার্স্ট মিটারটা কোথায়? না, এইটা। এই ওটা অফ দ্য ইন, এটা না, অফ, এটা বড়টা ওদের। Yes, sorry, I tender my apology before he lost. In Abdul Wahab, he made a prayer independently to appoint him.
Yes.
Kindly comes to page 15. I read in the nature of mandamus, I am not reading. To appoint the petitioners.
Yes.
He want an appointment. On the ground, what are the grounds? That kindly see the grounds. Grounds number 1. For that the petitioner being the son have no capacity to livelihood. I am a poor person. I have no livelihood. I should be appointed.
Yes.
My first submission before your lordship. If he has to seek for appointment apart from compassionate appointment, that is to be done against a regular vacancy, published vacancy. He cannot come for direct appointment without responding to notification or advertisement or declaration of vacancy by the government. He has no right to move this writ petition.
No, he prayed for appointment on compassionate ground.
No, kindly consider. On compassionate ground,
Yes.
if he wants to
On
an
compassionate ground.
application for on compassionate ground, then he has to make certain submissions that I am a son and I am a right to apply and I have a right to be appointed and I have resources for appointment. I am eligible to be appointment and the dealership, the cost or the cost to be incurred for the dealership, I possess. I satisfy the requirements. But now he said ground number 1. Petitioner being the son, gap, kindly see, have no capacity to livelihood. As such, she made a prayer for issuance of licenses, both FPS and kerosene oil dealer, in his name in place of late father on compassionate ground. But I cannot reconcile the statements being the son of whom and as such he is not she, is he made a prayer for license PPS such and such. So one of these statement is confusing, cannot be given any meaning at all.
No, he is saying that he has no capacity to livelihood. This is objectionable.
My submission that with regard, if he has no livelihood, he cannot maintain a dealership, true dealership. All dealership.
Statute says when a dependent of a dealer having no sufficient means of income can apply for license.
he cannot apply for, this is not a compassionate appointment in service. Kindly consider, where money is not required. Compassionate appointment in service, my lord has experience. That
No, I am not asking about service.
No,
I am
no.
saying about the statute.
the,
26.
I will show the statute.
Yes. Now
In
they are saying
compassionate
that the
appointment
no
is the
sufficient means of income. There is a term, no sufficient means of subsistence.
compassionate appointment is a term applicable in various circumstances.
Yes.
One compassionate appointment comes in service matters. Another compassionate appointment has been introduced here in respect of dealership. Now, in respect of dealership, if he claims compassionate appointment, he has to establish before his lordship, that is the resources
To run the business.
on the business.
That you want to argue.
Yes.
When he has no livelihood, how he can run the business? That is your submission.
That is my
Okay.
second. My second submission before his lordship, that and the second, kindly see,
Yes.
second submission cannot hold good. Other submissions I will not make on the first matter. Other submission I will make on second matter, because he changed the order of the directors. That is the crux of the matter now.
Yes.
Whether the order of directors will hold the field or will lordship accept the same or not. Now kindly comes to second matter.
The order of the director.
No, another submission. In this case, an application for addition of party has been made by 3 daughters.
Yes.
No, not this. No, it's not. Sorry, no, not this in this. Now, my lord, kindly comes to second matter. This is important matter. Kindly. Second matter.
Second matter. Yes.
Then, my lord, kindly comes to second matter. Herein, his lordship kindly consider 3 dates. Vilayat, the original dealer, Vilayat died on 31st of October 2023. Vilayat.
Muhammad Bilayat Ali. Bilayat Ali expired
Died.
on
31st, 3rd of October 2023.
3rd of October
No. Bilayat died on 25th of March 2023.
2023.
23 and 2013. So
2013.
13. I guess so.
Yes.
On the death of Bilayat, 2 applications made. One by Abdul Rauf, another by Minu Bewa.
Wife of the Bilayat.
Both the writ petition were dismissed.
Both applications are dismissed.
Both the writ petitions are dismissed.
Okay.
Appeal preferred. We moved the writ petition against same order, 25th of August 2014, page 49.
Page 49.
No,
No, page 49.
that is page 44, capital A. 44, capital A. There is a legible copy. Kindly comes to 44, though in page 44, your lordship will get the, but it is a hazy order, hazy. It is reprinted at page 44A.
Yes.
In compliance with the order of the Honorable Soumitra Pal, Minubeva, Justice Minubeva Maloto, may elaborate the facts.
No, sir. You just proceed. I know the fact.
Because your lordship remembers 2 minutes, otherwise my argument.
Okay, you proceed.
Minubeva came before Honorable Justice Soumitra Pal. An order was passed. That order your lordship will be pleased to find at page 32. Now, this is a nexus with the main order.
Yes.
Page 32.
Yes.
In the read petition, petitioners prayed for a direction upon the respondents on the subdivisional controller. Kindly consider this. On the subdivisional controller, food and supplies, is respondent number 6 to consider his application for transfer or MR dealership license and kerosene oil license, which was in the name of Muhammad Vilayat Ali, her husband, and on compassionate ground, it is submitted that though representation was furnished on 30th of February, 3rd February 2024 before the respondent number 6, however, it has not been considered aggrieved, this writ petition has been filed. Having heard the learned advocates for the parties and considering the facts and circumstances of the case, and the writ petition is disposed of by directing the subdivisional control. Kindly remember, subdivisional controller, food and supplies, the respondent number 6, to dispose of the representation dated 3rd February 2014 for transfer of MR dealership license, kerosene oil license, which is standing in the name of Muhammad Vilayat Ali, in favor of the petitioner for passing a region order to be communicated to the parties within 4 weeks from the date of representation, such and such, and after giving an opportunity of hearing and making necessary inquiry in accordance with the provisions contained in West Bengal Public Distribution System Maintenance and Control Order 2013 and the West Bengal Kerosene Control Order 1968. If it is found that the petitioner is entitled to the orders as prayed for, the respondent number 6 shall take follow-up action immediately. It is however made it clear that I have not gone into the merits of the matter and all points are kept open. But since the matter was and open to the dealt with by the respondent, since this matter was disposed of in my presence, I was not made a party. I prefer an appeal by leave to appeal, by filing a leave to appeal.
Yes.
Then the appeal court said, page 38, having heard the learned advocate for the respective parties, considering the amendments, my lord, I am not reading entire because your lordship has seen relevant portion. I am only page 40 middle.
Yes.
Having heard the learned advocates of the respective parties and considering the facts and the circumstances of the case, we dispose both the application as well as the appeal upon treating the same appeal as on today's list by directing the respondent subdivisional officer, food and supplies Malda, to consider the claim of the appellant, that is myself, appellant, petitioner hearing along with the respondent number 1 that means Minibewa, for grant of MR dealership and kerosene oil license on compassionate ground to, in view of the death of erstwhile licensee, namely Bilayat Ali, who is the father of the said appellant petitioner. Needless to mention that respondent subdivisional controller food and supplies, Malda will consider the claims of the appellant petitioner herein as well as the respondent number one lead petitioner for grant of MR dealership and kerosene oil license in question on compassionate ground strictly in accordance with law, especially taking note of the relevant provisions of the control order which are applicable in this regard. Although now you'll also kindly see there was a control order of 2003. That control order was repealed in 2013. Two 2013. The date was 8th August 2013.
Yes.
8th August 2013. Since the vacancy, since the death occurred on 25th of March 2013, I took the point that 2003 control order will occupy the field. You will also remember the word meaning of occupied field. That is the jurisprudential law, occupied field. As such, the division bench said, whether 2003 rules will apply or 2013 rule apply. Division bench said, strictly in accordance with the law and especially taking note of the relevant provisions of the control order which are applicable in this regard. Now, my lord,
Bilayat Ali expired in the March 2013.
25th of March.
25th of March 2013.
8th August
So,
2023.
Impugned order, wherein the minimum application was turned down, it is after August 2013.
Law came into force on 8th August.
8th August. So the decision
the period prior to that, whether 2013 rule can be applied.
now whether the decision impugned order passed after the promulgation of 2013 control.
No, that is a separate aspect of the matter. My first submission before your lordship. It is an academic discussion. First
Yes,
point
that's why I am asking you.
before your lordship. 2003 occupied the field up to 8th August.
Yes.
Death took place in March 2003.
Yes.
13.
March 2013.
So, the repeal clauses cannot be extended to up to before the birth. Kindly see the repeal clauses. That point was taken into consideration by the division bench. Kindly see.
Section 42.
42, kindly see. Rule 42. My lord, may I take my book? This
I have
is
the book.
New book is there.
Yes, I have the new book.
I see.
Yes.
No, this is the new book because I will argue later on with regard to certain portions of law, statute has been not properly quoted in Guru
Bodas.
Yes.
Gurubodobas test obviously.
It has not been quoted. As such, whether that judgment will be followed by your lordship, there is a question to be decided. Because if the law is quoted wrongly, and then decision should be wrongly made wrongly. Whether Guru Bodo will be applicable to your lordship, that is the point to be decided. I will argue before your lordship.
Okay.
There are some questions of law are involved in this case. Can you see the rule 42?
Yeah.
The West Bengal Public Distribution System Maintenance and Control of 2003, such and such, is hereby repealed. Notwithstanding such repeal, it shall not affect any proceeding, investigation, penalty for any offence by the licensee. Investigation
Proceeding, investigation, and penalty.
by the licensee
Yes.
for any offence by the licensee in respect of the provisions of the orders. Anything done or any action taken purported to have been done or taken, including any inspection done or any order made or any notice issued under this repealed act, insofar as it is not inconsistent with the provisions of the order, be deemed to have been done or such. There is no notification of vacancy. There was no notification of vacancy. It was continuing because some tagging was made to others. So whether this 2013 rule will apply, 2013 rule will apply.
On plain reading, anything done or any action taken or
When anything done or any action taken by or purported to have been done or taken, including any
any
inspection,
done or any order made or any notice issued. So
there is
are
no order, no notice.
no impugned order.
Impugned order, no. Impugned order was not at the
After
present
the-
moment. I am
after
not
the
arguing
amendment.
on impugned order. Impugned order is 25th of August 2013. 14, sorry.
Yes.
Impugned order.
Impugned
Now,
order
before-
rejecting Minu Beva is 14.
I am just giving the outline. Now you lordship can say the date. This is an academic discussion on law. With regard to interpretation law, your lordship knows various judgments, various
Yes, you
interpretations.
please proceed. You please.
We have read Sirbai fast. When we came to the bar, we read Sirbai fast to understand what is the constitution, Sirbai. Now, my lord, kindly see 42, I have read your lordship. Now, kindly see page 44. Kindly see page 44. What is page 44 is a hazy one. Kindly comes to page 44, capital A.
Yes.
After the revision of the order, this order was passed. In compliance with the order of the Honorable Justice Soumitra Pal in such and such, Minibaba such and such, Justice such and such, being the respondents number 6 gave an opportunity of hearing to Abdul Rauf Minibaba in support of their claim regarding license of MR dealer and SKL dealer to in place of late Muhammad Bilayat Ali on compassionate ground on 5th of August 2024. As the Minibaba has already submitted application for MR license, SKL dealer license on 3rd February 2014. And this order is my protoplasm.
Yes.
With necessary document in respect of claim and record inquiry regarding eligibility has been done by SEI recommending her name, Minibaba's name.
Yes.
However, Abdul Rauf, one of the son of late Muhammad Bilayat Ali, has also made appeal for MR, that will not be appeal application for MR dealer license and SKO in his favor, such and such. That is an appeal other thing. On the basis of above facts and as a provision of West Bengal Public Distribution System 2013, now he has applied 2013. Clause 20, sub clause 6.
Yes.
The applicant Minibawa, widow of ex-licensee, Muhammad Vilayat Ali, will get the first preference for getting MR dealer and SKO dealer license. As the no objection is not necessary from the other family members as per rules 2013, where applicant is the spouse of the deceased licensee. Correct. So objection of Abdur Rauf cannot be taken into consideration. However, as Abdur Rauf is also seriously interested for getting MR license in place of late Muhammad Vilayat Ali, his claim may be taken into consideration as second preference, subject to filing of required criteria if the application of Minimum arrive and get required approval from higher authorities. There is some word missing, I think. Oh, subject to full filing of required criteria if the application of Minimum failed to get accord approval from higher authorities. This is important. And this document is my protoplasm, and their document is 20 subclause 6. Now, this order was challenged by me, saying that I should be given the first preference. Minimum file read petition. No, in view of this order, I should be given appointment. What is the reaction of the High Court? Kindly. That order has not been annexed before your lordship. Just meet Darasheko, passed an order, such and such, I am not at the moment, but appeal was preferred by both the parties. Ultimately, this petition was dismissed, then division bench passed an order where facts have been considered, so it has not been annexed at the moment. Kindly comes to page 189. 189. Kindly see, 2 intra-court appeals have been directed against the judgment and order dated 2nd February 2018, passed by Honorable Single Judge of this Court in WP 33586 W of 2014, WP 25789 W of 2014. At that point of time, WPA number was not given, was not introduced, whereby the prayer of the writ petition are dismissed. Well, the statement has been made, such and such. Kindly, at the present moment, entire facts I am not reading because it will not be necessary. Kindly comes to paragraph 9. Paragraph 9 of the judgment, page 192. Only one paragraph I will show and the penultimate part. Page 192, paragraph 9.
Yes.
In compliance with the direction, this is also division bench order. In compliance with the direction, subdivisional controller food and supplies Malda gave an opportunity of hearing to Abdur Rauf and Minugawa in respect of the their claims regarding license of malt dealer and kerosene oil dealer in place of Vilayat Ali on compassionate ground on 5/8/2014 and passed an order 25th of August 2014, which is stated as follows. 25th August 2014, I have already placed before your lordship. I will not read the order. Now, my lord kindly comes to penultimate part of the judgment, page 208.
Yes.
Now, my lord kindly see page, paragraph 37.
Yes.
Respond number 7 and 8. That means subdivisional controller or district controller are directed to give effect to the orders dated 25th of August 2014, passed by the respond number 8, subdivisional controller, and conclude the proceeding for appointment of fair price shop dealer and kerosene dealer under the appropriate order within the 3 months from the date of this order and communicate the same to the appellant under the appropriate order. The fallacy still remains. Legal bond still survives. Whether 2003 will apply or 2013 will apply, division bench did not decide the same. Though that is the crux of the case, division bench did not decide the point.
Yes.
Now, one of the division bench said, 25th of August 2014 order will occupy the field. This is a farm. This was not challenged by Minimum
Yes.
or Abdul Wahab, whatever may be the same. This order I have not challenged, nor Minimum challenged, nor Wahab challenged before the Supreme Court. This order becomes final. It is attained finality.
Yes.
Now they say, now this Abdul Wahab now says, Abdul Wahab said that I have obtained no objection from 3 sisters. Though Abdul Wahab is not giving no objection, but since my sisters have given no objection, I am entitled to license. But with regard to that particular no objection, my 2 submissions before your lordship. One, can you see their affidavit. Page 237. Page 237. And one thing before this. Candy comes to 236. My lord has vast experience. Page 236. 236.
Yes.
This is a joint affidavit of 3 daughters.
Yes.
And your lordship will be astonished to see Habiba Bibi, Roshan Bibi, Shahana Bibi said, we are all the daughters of late Muhammad Vilayat Ali. my lord, they are married persons. They cannot affirm the affidavit deleting the name of the husband. It is impossible thing. They maintain the name of father, Bilayat Ali, but without giving the status that they are married persons. This affidavit cannot be accepted. Under the Oaths Act, this affidavit cannot, because he has to give the description. Your Lordship knows the Oath Act Section 4. He has to give the details of his birth and status, married or unmarried, or father, such and such. They do not say they are married. But Abdul Wahab, kindly see, my lord, page 237, last second page, next page. Abdul Wahab said, next 238, next page, kindly see, 238.
Yes.
Abdul Wahab said, Habiba Baby married daughter, 57 years. And they have got their own sons and own residential houses. I filed an affidavit because these particular persons have come up with an application for the addition of parties. I have given the details, their status, husband's name, sons and daughter's name, everything. Now, my lord, I am going to the same issue is otherwise. Still, this is a circumstantial issue. I have to address your lordship. Kindly comes to the order impugned now. Order impugned now. Impugned order, a repetition of facts, page 275.
Yes.
Repetition of facts. I am not reading the entire order because your lordship also entertained one of the writ petitions before your lordship, this writ petition, the first writ petition, and your lordship passed an order earlier, page 278.
278.
First paragraph, last sentence. Because when the first writ petition was moved, your lordship passed an order that at that point of time, notice was given for hearing by the director. Then your lordship said, also filed WPA number 4740 of 2023 before the Honorable High Court. Honorable Justice, my lord, passed an interim order in the matter of WPA 4740, can number such and such, directing as follows. The petitioner submitted that one notice was served upon him for personal hearing before the authority concerned. The petitioner is directed to appear before the concerned authority, and they are at liberty to inform the authority concerned regarding the status of the matter. Then, my lord, I am reading. The District Controller of Food and Supplies, Malda, took personal hearing of Abdul Rauf and Abdul Wahab and all other family members of late Bilayat Ali. He observed absence of mutual trust among them. According to the District Controller of Food and Supplies, the family members appeared before him as two opponent parties. Abdul Rauf on the one hand and Abdul Wahab along with their three sisters on the others. None of the rival parties was ready to give NOC in favor of the others. Attempts to form partnership formed by them also failed. under the circumstances, the District Controller of Food and Supplies Malda has sought approval for declaring the resultant vacancy in place of the deceased dealer, late Bilayat Ali. Accordingly, before taking final decision on the matter, both Abdul Rauf and Abdul Wahab were called for a hearing. V-Day noticed under such and such dated 5th September 2024, hearing was taken. That is, director is taking a hearing. Hearing was taken through video conference on 11 September 2024 in virtual presence of Sub-Divisional Controller of Food and Supplies Malda, Sadar Abdul Rauf attended the hearing, but his brother Abdul Wahab did not attend in spite of the order passed by Your Lordship. Your Lordship directed him to appear. Now, my Lord, kindly see, Abdul Rauf has submitted that hearing in that he assisted his father in running shop, running business, and he was dependent on him till his death. He submitted his first application in the year 2013 and submitted fresh application on 5th February 2022 after demise of his mother. One of the first preference which was given to Minu Bawa, that is gone because Minu Bawa died in the meantime. After demise of the mother, he has claimed that mother died. Mother died on 8/8/2000, 3rd November 2022. Mother Minu Bawa died. So claim of Minu Bawa is no more as a spouse, is surviving. Now, second preference has to be converted into the first preference, which is myself under the division bench judgment. They have now come to overrule the division bench judgment, which is not possible under the legal system of India. Because single judge is bound by the division bench judgment in view of decisions, a catena of decisions of the Honorable Supreme Court.
Yes.
Abdul Wahab, another son of the deceased, did not attend the hearing. Subsequently, through a letter dated after hearing is concluded, he has submitted that he received the hearing notice through WhatsApp in the last moment on 11 September 2024. For his illness, he could not appear for hearing. He has not prayed for any further hearing. Anyhow, that chapter goes. Now, examining case records and submissions of Abdul Rauf, one of the applicants, it is found that none of the applicants could obtain no objection of all other family members as required under para 26 for engagement of a daughter, engagement of a dealer, or compassionate ground. More than 11 years have elapsed since the date of death of the licensee. PDS in the area is being hampered due to prolonged tagging of the beneficiaries within neighboring FPS. The department cannot wait for indefinite period for settlement to dispute in particular family and filling up the vacancy on compassionate ground. But this finding is wrong, inasmuch as judicial proceeding cannot create an hindrance or bar with regard to relief under the 226 jurisdiction before this High Court. This is the personal right, legal right, fundamental right. Both the parties are fighting before the court, proceeding pending before the High Court, and they cannot blame that we have not explained the particular delay properly, that we have delayed the matter. No, proceeding was before the Honorable High Court. We have not delayed anything. So there cannot be any publication of advertisement before the issue is decided finally. Now what they have done, now my lord, second, with regard to this, or another submission before in this matter, my lord, a report was given by the department itself, page 243.
Page
243. Before the Honorable High Court, by your affidavit. On behalf of respondent number 128, kindly consider page 245. On behalf of respondent number 128, it starts as 243 and the affidavit 245. I not got it.
yes.
Now, report in the form of affidavit on behalf of respondent number 128. Who are the respondent number 128? State of West Bengal, Joint Director License, Commissioner of Food, Director of District Distribution, Procurement, Supply, such and such.
Yes.
Director also made the affidavit saying, page 249, kindly comes to page 249. However, Minu Baba died on 3rd November 2022. That is prior to the deadline dated 12th of November 2022 for giving effect to the order dated 25th of August 2022. On the death of Minu Baba and post the order of division bench, such and such, in order dated 2nd August 2022, order dated 25th of August 2014, must be given effect to. He said, order dated 25th of August 2014 has to be given effect to on failure of Minu Baba's application being approved. Second preference for the licenses will be given to Abdul Rauf. Therefore, currently application of Abdul Rauf is under consideration. How there can be advertisement to my exclusion without deciding the issue finally, which is pending before the court. Now, my lord, their affidavit, you lordship can see. Another submission I am making. He has filed application. Filed application. $249. We have given our affidavit in opposition. We have given our affidavit in opposition. Oh, well, given our evident opposition kindly comes to paragraph 4. We have said all the affidavits are false. Paragraph 4. I deny this statement, say that married sisters have no right and no role to play in the license in question. In affidavit in opposition, affirmed by Abdul Rauf, I have stated the married sisters have no right and no role to play in the license in question. That is, no objection obtained from the married sisters are all manufactured and fabricated. Number of, I am now at the present moment, at this stage, I am showing a portion from Mohammedan law of Mullah. My Lord knows this system. Kindly see Mullah. What Mullah said. Kindly see Mullah.
For what? For
Mullah.
what you are showing Mullah?
Mullah.
Why you are showing? No, why
Mullah.
you are showing Mullah?
Mullah, my Lord, kindly paragraph, page 30. Kindly see the page.
No, why you are showing Mullah?
Mullah. Mullah, principles of Hindu law. Mullah said, in Mullah it is said,
No, why are you showing Mullah?
because the daughters have come to claim interest in the license. In Mullah, it is been quoted, stated, Your Lordship is a Mullah books is an authority. In the Mullah said that the daughters, I am reading,
No,
the daughters
personal
has
law
no
is
right.
not applicable. Personal law is not applicable in the code.
Yes.
No, personal law is not applicable in control order.
Control order.
Yes, control order said the family. Family is defined there.
Family defined here.
Yes.
Now
So we have to go through the family only, not the personal
family
law like that.
No, my Lord, kindly family. Kindly
Yes.
see family.
What is
there
the family definition of family? That has to be
No,
looked
in
into.
family there is some exception. Kindly see. Family will not apply automatically. Kindly see family will not apply automatically. Wrong submissions were made by my learned friend, who is wholly dependent on the dealer.
Yes.
Otherwise, he will not be eligible. Married daughters, having sons, having property, how they are wholly dependent upon their father. How these affidavits have been filed and accepted and annexed to the writ petition. Law does not permit. Wholly dependent.
Moreover, you read the family, definition of family.
Definition
of family 2M.
Family daughter, kindly see.
Daughter.
Daughter,
including daughters.
Kindly see, including daughter, legally adopted before death or incapacitated, divorced daughter and widowed daughter,
Yes,
not married daughter.
Not the married daughter.
Not the married daughter. How they can come in? And they have also filed an application for addition of parties. What is going on?
Yes.
Now, my Lord, my submission before His Lordship, the and now one submission, one document I am trying to show before His Lordship. He has annexed his application. Kindly comes to page 161 Abdul Wahab. 161. He has filed an application for license. What he stated, financial capacity, page 161. Bottom, my Lord, can you say bottom?
Yes.
Rupees 2,000 only. His annual income.
Monthly income.
Monthly.
Yes.
Monthly income 2,000.
So your first submission is he cannot run the business.
No. Then, my lord, kindly see the government document. Then kindly see my read petition. Then kindly see my read my read petition. My read petition is very short. I have only said order of the director is not sustainable in law so far. Exclusion, so far my exclusion is concerned, and so far declaration is concerned. 2 points. First preference, second preference should be transposed to first preference, and declaration is illegal. 2 points.
Yes.
Now, my lord, facts your lordship knows that unless I will be repeating. Only another submission I am making before your lordship. The judgment I will now, judgment at the moment I am not distinguishing, I will distinguish later on. Now, with regard to my read petition, these are the 2 grounds. I will not repeat the paragraphs. Now, kindly see the government documents. Government has filed documents. Government has filed documents. These are, my lord, government has filed documents. Kindly see the government documents.
In which matter?
দেখেছো ভালো এফিডেভিট তো না এইটা দিয়েছে আমাকে না না অপোজিশন আমাকে দেওয়া হয়নি no no but I've been given the list of documents not
Show me, just show me. Just show me.
this has been given to me not opposition.
Yes, I got it. I've got it.
I'll only point out 2 points from here. Kindly see 2 points. Kindly see, my lord, running paragraph, page 4.
Running page 4.
My lord got it?
Yes.
I'm not reading and in pursuant to the order dated, second paragraph,
Yes.
paragraph 4, second paragraph. In pursuant, but the English is wrong. In pursuant, the English is wrong. In pursuant of the order dated 24th of October 2024, resultant vacancy has been initiated on 10th of 12th 2024. Petition is pending from 2003, 2023 before your lordship. Your lordship passed an order to appear before the director, and now they have declared the vacancy on 10th of December 2024. How? The contempt to us. I will show authority before your lordship. It is the contempt to us. To frustrate our writ petition, this has been done. It has to be deprecated, the action of this particular person. Now, my lord, kindly see, secondly, they said, now being aggrieved by the above order, which order? Being aggrieved by such and such, Abdul Wahab, such and such, correct. 24th of October 2024. 24th of October 2024, I read out before your lordship. I will not repeat all these things. Now being agreed by the above order 24th of October 2024, that is the director's order, my daughter has seen, the petition of the Rove, another son of deceased dealer, Mohammed Bilayat Ali, filed this before this Honorable High Court of Calcutta. It is not stated that my claim is negative. Now, with regard to financial position of myself, it logically comes to page 9. My application.
Yes.
Kindly see, monthly income 80,000.
You said annual.
Monthly income can't you see? Oh, annual income 80,000. Sorry, attended. 80,000. So I am competent. I am eligible. My eligibility has not been questioned in the report. Kindly see paragraph 4 of the report. My eligibility has not been controverted by them.
Okay.
And your lordship's order has been enclosed here, page 17. Page 17, my lord's order has been annexed here. This is an application for restoration of recalling or recall. The petitioner submitted the other.
The petitioner directed to appear before the concerned authority.
Yes, my lord's order. And with regard to my stand is, I don't want to deprive my brother. I said, both of us do the business. Both of us. But Abdullah said before them, no, I said, I want to do business with my brother. Kindly see, which is the malafide and which is the bona fide. Kindly consider the same. Why I am preferring for first preference or in view of their own documents. Well, kindly consider how these particular officers allowed the married daughters to depose before them. Can't you see? Something wrong is there. Page 13, page 15, one Shahana Bibi, they examine how Shahana Bibi come, how these married daughters come. They ought to have understood, wholly dependent. Then page 17, Habiba Bibi, I'm not reading. They said, we want that our younger brother should get it. Even, my lord, no state, even, can't you see? Habiba, the officer, describe her, page 15, daughter of Bilayat Ali, who is the husband, that was not taken. In the oath before the court also, you also always insisted that why if the married husband name must be there.
Yes.
Some collision is there, my lord. My statement, my lord, can you see? My statement, page 23. 24. আপনারা দুইজন আব্দুর রব আব্দুর রহাব সকল ভাই বোন মিলে পার্টনারশিপ ভাই বোন হোয়াই বোন হোয়াট ইজ দিস পার্টনারশিপ করতে রাজি আছেন রাজি থাকলে না থাকলে বলুন উত্তর আমি একাই ডিলারশিপ নিতে চাই পার্টনারশিপ করতে চাই না ও this is Abdul Wahab is saying Abdul Rof. I'm showing here Abdul Rof. Sorry.
Page 22.
Your Lordship,
Page 22.
20. Oh, yes, page 21.
Page 22, 7. 7.
My Lord, vast experience. Can we see? Yes, page 22 bottom. আমাকে আমার ভাই এনওসি দেয়নি, আমিও ভাইকে এনওসি দিতে চাই না বা দিইনি, কিন্তু আব্দুল ওহাবের সঙ্গে পার্টনারশিপ করতে চাই। And kindly see the reaction of partnership, Abdul Wahab, page 24. আমি একাই ডিলারশিপ করতে চাই, পার্টনারশিপ করতে চাই না, আমি আমার দাদার সঙ্গে পার্টনারশিপ আব্দুল রব করতে চাই না।
Yes.
He will be the monster. He will be the monster alone. He will kill everybody. He will eat everybody. Now, what is the law? Can you see? Your Lordship, vast experience I find from Your Lordship, because Your Lordship is ready before us. Your Lordship has seen many things. My Lord, I am referring to Your Lordship one case. What is the power of 226? We are now before Your Lordship 226. This is not a suit. It is a plenary jurisdiction. Your Lordship is having power more than that of Article 32.
Yes.
Now, Supreme Court said in Benedict Dennis Kenny cases, Your Lordship, powers of the Supreme High Court, kindly consider paragraph 21 to 27. I'm showing, I'm giving, একটু kindly. হ্যাঁ, ওটা পড়তে পারবেন, এটা পরিষ্কার আছে, এটাতে। When it kindly comes to page 20, paragraph 21.
Paragraph 24.
Paragraph 21 to 27, paragraph.
Okay. Okay.
And 34 to 37. Can you see paragraph 21? My Lord, we need to first notice the nature and extent of a jurisdiction of the paragraph 21.
Yes.
We need to first notice the nature and extent of jurisdiction of the High Court under Article 226 Constitution of India. The power of judicial review vested in the High Courts under Article 226, this court under Article 237 is an integral and essential feature of Constitution, is basic structure of our Constitution. Jurisdiction under Article 20 is original, extraordinary, discretionary. The lookout of the High Court is to see whether injustice has resulted on account of any decision of the constitutional authority or a statutory authority or a tribunal authority within the meaning of Article 12. Injustice. Second preference has to be transposed to first preference under their own order, which has been informed by the division bench. What more remains there? One submission, another one document I have not shown before. Government document published. Only one, kindly can. Government. My Lord, one, my Lord, I tender my apology. With regard to government documents, the government declared the vacancy, page 25.
Yes.
They have stated also in their note sheet. We have declared the vacancy on 10th of December 2024. They have annexed the documents. But this should be cost. On 25 and 26.
No vacancy has been declared. It's a proposal. It's a
Proposal for
of
previous vacancy. Now what they say, it can you see, rule page 4, in pursuant to the order such and such, a vacancy has been initiated on such and such.
Has been initiated, but not
Initiated, that means it will be published.
Yes.
Initiation is very initiation is bad. Article, Your Lordship, Article 32 is a lion. Article 26 will jump into the injustice. Where is there? There is no binding with regard to party powers. The lookout of the High Court is to see whether injustice has resulted on account of any decision of the constitutional authority or tribunal, such and such meaning of article. The judicial review is designed to prevent cases of abuse of power or neglect of a duty by the public authority. Here is a neglect. They say I am entitled to second preference. When first preference goes, I am entitled to be transferred to the first preference. It is there. It is their neglect for which I have to come before your Lordship. Jurisdiction for the enforcement various rights of the public to compel public and to discharge the public function entrusted on them. They are not discharged. On the other hand, they have taken the law in their own hands. Initiation has been made, though matter is pending before the Honorable High Court, which is directly a contempt. The courts are guardians of the rights and liberties of the citizen. They say they shall fail in their responsibility if they abdicate their solemn duty toward the citizens. The scope of the Article 2 is very, very wide, can be used to remedy injustice wherever it is found. Other paragraphs I am not reading because it will take time. Second, my lord, I am submitting before your lordship. That is also on. That is also on 226 power.
Yes.
Current judgment, one current judgment I should submit before your lordship, because unless I file a current judgment, I will be failing in my duty. 2024. The lordship kindly comes to page 1, paragraph 138, 139, 140. I am giving the paragraphs only, entire judgment I have not given. You know, citation কি দিলাম জানি না। Pedantic English has been written. But I was reading the judgments of 52, 54, so you will also read the judgments. Reading the judgment of Justice Iyer, pedantic English. Though you are the student.
Copy. Extra copy.
You will also.
Extra copy.
Extra?
You have given me 2 copies.
So, now, my lord, I will distinguish Guru Podo. This
Yes.
is my last submission. Now, my lord, can you say Guru Podo?
Today or any other day? Are you ready today?
I will go. Oh, within 10 minutes, I will complete my submission.
Okay.
No, I will complete my submission.
Okay.
Because I have now seen my experience today before your lordship. Repetition is not necessary before your lordship. Repetition is not necessary. Now, my lord, I only distinguish Guru Bodo. My lord, I will give you lordship because I have got the AIR publication, but it is hazy. It will not be your lordship. Then I am giving you lordship Supreme Court online.
Okay.
Supreme Court online. Supreme Court online.
SCC online, I have the copy. I have the copy. Guru Das, SCC
Supreme Court
online.
online.
Yes,
No, can't.
I have the copy.
I've got the AIR also Calcutta. AIR, it has been published in Calcutta also.
Very well.
We
We can deal with SCC online.
That is Calcutta. I know, I follow. Kindly reference, your lordship knows that Calcutta reference?
AIR 2022, Calcutta 331.
331, correct. Then I will not. Kindly see. Paragraph 10.
Yes.
Herein, on our division bench, quoted cross 20 and subcross 4. Now, your lordship kindly takes this book. Orator, kindly take this book. Is up to date. This is containing amendment. Engagement on compassionate ground. Then from the judgment I'm reading, then your lordship read from the books.
Yes.
Engagement on compassionate ground in cases of vacancy arising out of death or in case of incapacitation or on medical ground, subject to the satisfaction of the authority of any existing dealer, such vacancy shall not be initially be notified. Prayer for any of the family member initially be not notified.
Yes.
Prayer of any family members of the deceased oblique incapacitated dealer having no regular means of subsistence. Now by amendment, what subsistence has been omitted? Income.
Means of income.
Income.
Yes.
Will be considered with preference on compassionate ground, provided such prayer along with formal application in 60 in Form C, along with Annexure 1 with requisite fee is submitted within 60 days from the occurrence of such vacancy. Well, now kindly see book. Yes. Kindly see.
First provision, 90 days. First provision, 90 days.
First, hearing also, while applying, one of the hearing while applying the applicant shall have to furnish no objection from the
other family members.
Such form in the applicant about. Now, my lord, kindly see the present rule. In case of death or in case of such and such, can be informed affidavit shown in such and such. A corroborative documents, my lord, can you see? A corroborative documents as per checklist, no objection from any other members in the form of affidavit to be shown before a magistrate in Annexure 2 is submitted. It is not there in the. Provided in case of death or license, prayer is submitted within 90 days. This particular portion is also not there. Provided licensing order may on just and sufficient, such and such, up to 120 days. But in the judgment, kindly see, your lordship, lordship knows the judgment. Still, kindly only the parameters laid down by the court. I am showing in lordship parameters. Kindly see paragraph 19. Paragraph 19. Now the most important question is, what is the meaning of no objection from other family members? Family members have been defined in clause 2M. Family member means spouse, dependent parents, dependent sons, and dependents the purpose considering engagement or dealers, distributor, or compensation account. Wholly dependent, this sentence is absent. It's not there. Now the parameters which have been let down, that the guideline, I should say guideline, paragraph 26. It now cannot hold the field in view of the amended provisions. As such, the judgment is in sub silencio.
Sub silencio. For wrong quoting of the provisions.
These are. Now I conclude my submission today because my lord is not necessary to argue all the not necessary to argue all this thing. Let them argue. I mean, only one affidavit I am filing, one application for addition of party. Oh, they file supplementary time. Now, my lord, my submission before last submission. Only two minutes. Only 2 minutes. Only 2 minutes. We are now before a had it been contrary to judgment of earlier court, it would be per incuriam. Since in view of the in respect of statute, city provision, sub silencio. Your lordship knows this is different.
Yes.
Now my submission now I conclude before your lordship. I am now before a court under Article 226 of Constitution of India. Injustice has been caused to me. I am found to be eligible to get the license having second preference. Second preference, if first preference holder does not survive, second preference should be transposed to first preference.
Yes.
Third submission before your lordship, my income is sufficient for the
To run
purpose
the
of
business.
the married daughters have no right.
They are not included in the family. Definition of
I will
family.
not repeat the Your Lordship. Your Lordship. I will not repeat the phrase. Your Lordship has taken care of all the facts, all the law.
Yes,
As such, I am not wasting Your Lordship time.
that's all.
That's all.
Okay, thank you.
My Lord has got this book.
Yes. Have the same book. Did-
This book only keep the
Yes,
book.
I have the same book.
Oh,
You are for?
For the state, Mr. Shopon Banerjee and Mr. Dipanjan Dutta is for the state. If one opportunity may be given to the state to make their submissions.
Tomorrow?
Tomorrow,
Tomorrow কি আছে?
the deep time, my
Let them conclude thereafter.
the application that it overall reply.
Okay, okay. I will hear it out. So tomorrow? I
পিলে কেন হবে তো?
will go to ask.
পিল হয়ে যাবে। শুনানি হয়ে যাবে।
2 p.m. এটা থাকে। Tomorrow 2 p.m. Please take down. Argument on behalf of Abdur Rauf. Within bracket, petitioner of WPA number 3605 of 2025 concludes. Full stop. It is state to argue on that point tomorrow. State to argue tomorrow. Let the matter appear tomorrow at 2 p.m. 2 p.m. You don't need. Next.
Time for the item number 6, my lord.
Item number 6.
Yes, my lord.
Item number 6, it was learned senior advocate Mr. Agarwal was not there, so they have taken adjournment.
Okay. Grateful, my lord.
Not this week. Yes.
এদিকে এদিকে এদিকে
What is the matter?
With regard to allotment of dealership, paper of the respondent number 4
Respondent number 4.
and one the applicant, the petitioner, is questioning that allotment and selection of the respondent.
Very good.
Sir, I take your lawsuit to the very recruitment vacancy notification. That's a page 14.
No, you are the petitioner, you are running a business.
No. Well, I have not been selected illegally. That's my case. I am questioning the selection.
কোন ফাইলটা দিয়েছো?
Nurul Islam, I think.
Give me item number 7. Yes, Mr. San, I got the file.
Now your lawsuit, page 14 of the read petition is the vacancy notification.
Yes.
I request the lawsuit to take up the same notification and the exception we have taken to the report of the state That's more legible. That's why I'm requesting. Page 37 of that exception. I don't know. Okay. Everything of stated reported exception. But got that one or I have not that have not been filed.
Okay, I have that your report. I have the supplementary, but not the exception.
ওই ডকুমেন্টস গুলি অ্যানেক্স এটা লেজিবল বলে প্লেস করছি পেজ 37
If required, you serve the others. Okay.
right. But the same thing your lordship is not legible in the repetition, that's why I take your lordship page 37. Similarly, your lordship will find
Yes.
APS vacancy notice. Has your lordship got it?
Yes.
Dated 16th November 2022.
Yes.
Lord, we are concerned with your lordship, the APS Act Korondigi, your lordship will find in the encircle block or the police station Korondigi, your lordship will find block municipality or municipal corporation Korondigi, all that your lordship.
Bhikanpur PS FP school. This is the
Mouja Jadranchar Bhikampur Way GP Gram Panchayat, your lordship.
yes,
Oblique ward Altapur 1.
yes,
This is the Panchayat area and police station Korondigi. So this is known as Korondigi. It's FPS DLSC.
okay,
Wrong way too. Now your lordship will find clause 9 of this. There are certain clauses I take your lordship, then I will take your lordship document. So clause 9, last date of submitting application. The application can be submitted during working hours on any working day in the office as mentioned above or through online within 21 days from the date of publication of the indicative advertisement
yes,
of the FPS vacancy in the newspaper. It's your lordship. 21 days from the date of publication of the indicative advertisement in the newspaper. Now your lordship will find next page, page 38. Part 4. The applicant must submit the following copies or original supporting documents along with application in form. C. All photocopies shall be self-attested. I will be laying stress on this along with application form C. That means all the original copies required under this part 4 to be submitted with the application. If your losses kindly turn to the next page, your losses will find. Before that, your losses, may I take your losses to page 38 of the clause 6, part 4. Clause 7. It starts with the expression documents regarding possessional right over the proposed place of business.
yes,
Got it? Then kindly turn your losses to the next page. Demise of ownership or share ownership. Photocopy A. Photocopy of record of rights or registered deed of conveyance or purchase deed in the name of the applicant. B. Documents showing character of land as
Dokan commercial bastu.
or commercial bastu, whatever. If record of rights is not produced. C. Up-to-date proprietary tax, all that, and then other co-owners also. NOC of other co-owners. This is in case of shared ownership or exclusive ownership. Now B. Well, that's according to me, Malad, will be relevant. For lease / your losses will find, or rented property. Then colon, registered lease deed or tenancy agreement
Yes.
with copies of the rent receipts for all the months from the date of agreement till the date of application, and the registered deed or ROR, record of rights, in the name of the landowner or lessee. Therefore, your lordship, two persons can apply. The person having registered lease of deed, or alternatively tenancy agreement with copies of the rent receipts. Now, the next your lordships will find these are the terms of agreement. Now, another your lordship, part 5, clause 4. I just take your lordship to this. Everywhere your lordship will find that any suppression of fact or information or incorporation or providing of wrong information in the application form or attached document will be considered as a good and justifiable reason for disqualification for a candidate or rejection of application and taking appropriate legal action.
Yes.
I am questioning the selection and allotment of or offer letter in favor of the respondent number 4. Malad, let me first deal with that, then I will show that
You are the most suitable
qualified and
candidate.
I should have been set. Now your losses will find in this Malad read petition. Malad, I take your losses to that read petition page. This is your losses 38. I don't know Malad, your losses copy is equally legible or not. But
Page 38.
38, but my copy is equally legible.
I can read it. Yes.
Your losses will get a fair copy of this document in the supplementary affidavit. Page 8.
Okay.
Now, may I read it here?
Yes.
Lease agreement. Well, kindly see, every line has a meaning over this.
Yes.
Lease agreement. The lease agreement is made at Raigon on this day, 4th day of February 2023. Then between Robu alias Robul, aged about 49 years, son of such and such. Malad, kindly consider the name only. Rabul. 2. Anikul Hawk, son of Rabul. Therefore, this lease agreement between the father and the son. This is executed 4th February 2023, notarized. Malad, at the left hand side, your losses will find. Lease agreement notarized. Now, the next page, page 9. Whereas the lessor is the owner and possessor in possession of the property, these details described herein below. Well, your losses will find the land, your losses, Bhutian number such and such, land such and such. Your losses, I am not getting the dark number also here, but I will take your losses to the dark number from other documents. Kindly see the terms of the lease. Whereas the lessee has expressed the lessor to give on lease the above mentioned schedule of land for consideration of rupees 24,000 per year, and the lessor agreed to give the same to the lessor under the following terms and conditions. The lessee will pay a sum of rupees 24,000 on the first day of signing this lease by cash. Therefore, your lordships, this is a yearly lease rate. 2. Lease agreement will commence with effect from 1st day of February 2023. This was executed by notarized on 4th, giving retrospective effect from 1st. And kindly see the duration of lease for 25 years. So the amount of lease rent or premium. And the year is most vital here according to me. After completion of the term of the lease, and the lease may be extended with consent and discussion of the leisure lease, this is usual course. This will appear after expiry of 25 years. Now your lordships, kindly turn to the next page. Two terms are very important. Clause 7.
Yes.
Now, the lease agreement is valid from 1st February 2023 and ended on 13th day of January 2048, 31st January. That means for 25 years. It will be renewed after part 25 years, which is agreed by and between the parties. Now, another clause you will clause 5. The lessee paying the rent hereby and hereunder, reserve and observing the performing the covenants and the conditions herein contained, the lessee shall quietly and peacefully, this should be Malak.
Yes.
Hold, possess, and enjoy the said land during the said term without any claim, interruption, disturbance of the relation. But according to me, these clauses of the lease agreement fulfills all the conditions or features of the lease defined in section 105 of the transfer of property. Well, there must be a yearly rent, one. There must be for a certain year of, there is a considerable period of year, 25. And what gives the right? The right to enjoy the property. It passes the right of enjoyment of the property.
Yes.
So if these conditions are fulfilled, then it has to be registered now. Otherwise, this is not a lease. But I take your lordships to the section 105 of the yes. Should I continue your lordships with 435?
Okay. Just forget.
No, no.
কাজ করতে পারবো
Lordship, take it up. Tomorrow তো এটাও চলবে আগেরটা মনে হচ্ছে
মানে ডে আফটার টুমরো আই হ্যাভ সাম প্রবলেম
Okay. কি আছে কালকে পরশুদিন?
But if permitted your losses Wednesday, it will also possible. You can continue your losses.
হবে তারপরে গ্রুপ আচ্ছা গ্রুপ 2 কটায় আছে? দুটোতে গ্রুপ 2 আছে। কোনটা বলুন তো? ওই বোস ইনস্টিটিউট। গ্রুপ 2 তো অন্য ম্যাটার আছে।
So Wednesday at any point of time I can.
হ্যাঁ এটা ওয়েডনেসডেতে কি আছে? শুধু একটাই গ্রুপ 2 একটা আছে সেকেন্ড হাফে তো আর কিছু দুটোই fix it at 3 p.m. Wednesday. Okay. Good. Please take down. Argument on behalf of the petitioner continues. Let the matter appear in the list on 23rd of April 2025 at 3 p.m. Okay, thank you.